Today's courtroom ride starts with a defendant who walks into a preliminary hearing and somehow turns a bond request into a full tour through monarchy, Roman law, Germanic ancestry, Admiralty flags, John Wayne, Bob Barker, and a future multi-billion-dollar lawsuit. And that is just the first case. We are watching two sovereign citizen-style hearings where the legal system is trying to do something very basic. Figure out whether these defendants understand what is happening, whether they can assist their attorneys, and whether the court can safely move the case forward. But instead of straightforward answers, we get courtroom speeches, legal word salad, and a judge who has to stay calm while being compared to royalty. Pay attention to the bond issue, the parole hold, and the competency evaluation, because those three things completely control what happens next. And by the end, the big question is simple. Is this strategy, confusion, or a dangerous mix of both?
Mr. Holt is present in custody. He's scheduled for preliminary hearing. How would you like to proceed?
I filed a motion for a competency evaluation.
That's right.
May I ask you a question, Your Honor?
You may, but first let me explain something to you.
Yes.
We are recording everything that is said here in the courtroom, and anything you say about the charges you're facing could be used against you
I
by
understand, Your Honor.
the prosecutor. One of the reasons the state of Colorado gives you a court-appointed attorney is so that you could speak through your attorney.
Right.
I'm happy to give you a moment to whisper with
Right
your
away, the judge does something important here. Before letting Mr. Holt speak freely, the court warns him that anything he says about the charges can be used against him. That is not just courtroom politeness, that is legal damage control. Defendants often think they are helping themselves by explaining, minimizing, or arguing facts directly to the judge. But in a criminal case, every volunteered sentence can become evidence, impeachment material, or a roadmap for the prosecution. That is why the judge reminds him he has a court-appointed attorney. The attorney is not there as decoration. They are there to keep the defendant from accidentally turning a hearing into a confession buffet.
to whisper with your attorney.
I'd like to see if I could be released on my own recognizance pending the outcome of the case. It was like $3,000. I have, or what was it? I have the money on my debit card that's in Carrie Matthews has on her person. But I'm looking for a reduction in that, being that the case is not so egregious as perhaps egregiousness is. There was no threats, the weapon, the alleged knife. All right. I would, if you could consider a reduction, sir. What's the amount now? 2,500 or?
So the other complicating issue with bond is that he has a parole hold right now. I've reached out to the parole officer. They're not willing to lift it at this point, but we're going to keep trying. And so we've talked about sort of addressing that once we can get it lifted.
But I've heard that the sentence doesn't merit, it doesn't look like any menacing was even there on the cameras. It's Hope COS. And I would like the reduction to ROR. Not this does happen in this county where people do get ROR'd, and then pending the outcome of the case, if I'm found guilty, then I could go back to jail and then go to DOC. But I feel it's warranted that I could get the ROR. And if it's so much, it's on the debit card, and I could pay for that with Miss Matthews sitting in the back there.
In some cases, it is warranted, but in your case, it's futile because of the parole hold. And so I'm not willing to address it today, but if the parole hold gets lifted, then I'm willing to address it.
And there it is. The parole hold changes everything. Mr. Holt is asking for release on his own recognizance, basically saying, trust me to come back. But the court is explaining that even if the bond were lowered, even if the judge felt generous, the parole hold means another authority is still keeping him in custody. That makes the bond argument almost meaningless at this moment. This is one of those legal details viewers sometimes miss. A defendant can win one battle and still not walk out the door. So when the judge says it is futile, he is not being dramatic. He is saying the court cannot solve a custody problem controlled by parole.
To address it in the future.
I understand, Your Honor. I appreciate that.
Okay, now your attorney has raised the issue of whether you are competent to stand trial. And what this means is that I'm obligated by law, if I find good grounds, and I am finding good grounds, you're going to be evaluated by a psychologist. And this is going to delay the proceedings. And you have certain rights
Now, the
associated.
case takes a major turn. The defense has raised competency, and that is not the same thing as saying the defendant is guilty, innocent, or mentally ill in a general sense. Competency asks a narrower question. Does this person understand the proceedings, and can they assist their lawyer? If the answer is no, the case pauses. The court cannot just push forward because it would risk violating basic due process. So when the judge says he is finding good grounds, that means the defendant's behavior, statements, or legal posture have created enough concern that a professional evaluation is required. The courtroom is no longer just talking bond, it is talking capacity.
Rights associated with this evaluation.
Yes.
If you will bear with me, I would like to read you those rights. And when I'm finished reading you those rights, I'll ask you if you have any questions.
Yes, Your Honor. God bless you. I appreciate your levity and allowing me this moment with you. And I realize in the United States, the judiciary is, in fact, they bring kings and queens, heads of state, senators and congressmen to trial because the real king is, and because the heads of state cannot do it, the judge themselves. And for instance, the district attorney is like the you're the sire, the king, and they're sirs of the court, and they're also esquire. And so it's a parliamentary procedure is used, and it's a exercise in royalty.
This is where the sovereign citizen style language starts colliding with reality. Mr. Holt is trying to frame the court through kings, queens, esquires, parliamentary procedure, and some kind of royal hierarchy. But criminal court is not a medieval role-play server. The judge's authority comes from law, jurisdiction, and procedure, not a crown. And notice the contrast. While Mr. Holt is describing a fantasy structure of power, the actual legal issue remains painfully simple. He is in custody, there is a parole hold, and his attorney has questioned competency. All the royal language in the world does not unlock the cell door.
Hold. And I can appreciate your largesse, and I know you have a lot of power. You know the state judiciary and you know the federal judiciary. I just felt that people are after my life for being a Jewish American, and that it was contained in my pocket, and I just asked for a little mercy and your fortitude. And the Roman Empire is you in one person, because I'm also of Germanic descent, and so I asked that you could please see the tape at Hope COS yourself. In the it was in the but if you could have a little mercy on me, it's just a parole violation. And even if I did spend time, it'd be 6 months. Wouldn't be that much. It's no big deal, but I'm trying to put my life back in order in the street. I could avoid doing the 6 months. I've already done 1.5 years. It can't start over again. It's a 3-year tail. So the most it would be in 1.5 years, but then I should be customarily the 1.5 year tail is pretty much the rest of it is exonerated, having done 1.5 years anyway. So, but being that I've, for 6 months, all this, it takes quite a lot of the state's time and money to prosecute crimes with anywhere you go in this country. Is it really worth the court's time? You have a lot of egregious offenders, sir. And you are a king. You are a king. And the yellow fringes mean admiralty. We come from England, the bastion of common law. The Roman Emperor Justinian himself, being of Germanic descent, because, for instance, the law of stare decisis, common law. The Codex of the Roman Emperor Justinian, and a lot of German blood is actually, and England wouldn't be that way without Germany. So understand that Germany has civilized the world with common law, and Israel still uses civil law. Shoot. So, that's the reason why people use the straw man. That's wrong. What it means is that, believe it or not, I don't even think the world's coming to an end. It has many years to go. But, I personally have faith, and I believe goodness wears out or has the end of the day. But it's just going to be a real warm summer, the southern sky. It's going to be on average warmer. I just don't want to sit and waste the whole year in a cell. I'm willing to be conducive enough to handle myself appropriately.
So, Mr.
I
Holt,
just don't like the Aryans in there.
That exchange is brutal because the court is cutting through several minutes of rambling with one practical point. If prison conditions are unpleasant, the answer is not to commit new crimes or violate parole. Whether viewers find that harsh or fair, it shows the judge is trying to bring the conversation back to personal responsibility and legal reality. Mr. Holt keeps asking for mercy, but mercy in court usually comes after accountability, not instead of it. And this is where the audience question gets interesting. Should judges show extra patience when someone may not be competent, or should they shut down irrelevant speeches faster?
hang on. I don't blame you. Let me share.
Aryan nations, forgive me, officer, please.
Mr. Holt, I have the floor now.
Yes,
And
sir.
You're only allowed to speak when I give you the floor.
Yes, sir, Your Honor.
So I need you to listen to me.
Yes, sir.
It is a warmer than average year. And in an effort to maximize your chances of getting out into the warm weather, I need you to listen to this advisement.
Yes, sir, Your Honor.
And then when I'm finished reading it to you, I'll answer any questions that you have.
The
Yes.
judge uses a smart courtroom tactic here. He takes Mr. Holt's own comment about warm weather and turns it into a reason to listen. That is not just humor, that is control. Judges often have to redirect defendants without escalating the situation, especially when competency is already in question. Instead of arguing with every strange claim, the judge narrows the focus. Listen to the advisement, understand your rights, and stop interrupting. This is courtroom management in real time. The judge is not validating the rambling, but he is using just enough of it to keep the hearing moving.
Yes, sir.
So because your attorney has raised the issue of whether you are competent to stand trial, this means that you will be evaluated by one or more psychologists or physicians, and you have certain rights throughout this procedure. Since it is the defense that has raised this issue, this constitutes a waiver of privilege to any previous or subsequent competency evaluations. You have the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine your competency. Any statements you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify at any subsequent criminal trial. Any statement you choose to provide in cooperation with the evaluation may be used at any sentencing hearing held in the case if you are found guilty. You have the right to request an evidentiary hearing to contest any determination of competency. You have the right to be examined by an expert of your choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At such hearing, you have the right to be present in person to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court. You have the right to introduce evidence, summon witnesses, cross-examine opposing witnesses, or witnesses called by the court. And you have the right to make an opening statement and closing argument. If you are found incompetent to proceed, then the criminal proceedings would be suspended and you will be committed to the Department of Human Services for a period not to exceed the maximum term of confinement that could be imposed for the offenses with which you are charged. If committed, you have the right to request a hearing as to whether your competency has been restored. If you are found to be restored to competency, then the criminal proceedings will resume. Do you have any questions for me about any of these rights?
That advisement is dense, but it matters. The defendant has rights during the competency process, including the right to remain silent during the evaluation, the right to challenge findings, and the right to seek an expert. But there is a catch. Silence can still be considered by evaluators, and statements made during the evaluation may later matter in court under certain circumstances. That is why competency evaluations are not casual conversations. They can affect whether the case pauses, resumes, or moves into restoration. So when a defendant talks endlessly without focusing on the question, it can become part of the bigger picture the court is trying to assess.
Any of these rights?
Thing first, means I celebrate Germany because primarily the tribe of Judah is Germany. When the Arch of Titus Caesar went, they were taken to Rome, and which mostly is Germany. And so the Pax Romana is Roman law. The civil disabilities bears the hallmark of, well, let me just say, a German brutality, but it's not brutal. How do you stop all crime in Rome? Simply, people are reduced to pauper status. You can't vote. You can't have a job. You're nothing. You have no money. And see, I personally believe nobody does it like Germany, because England would not be England without Germany. Saxony is a part of Germany. So, I have Merovingian blood from Joseph Francis Holt. If you want to know the truth, John Southern, John Wayne is John Holt, and he is my real father. Ann Holt is our grandmother, and my great-grandmother is Anna Majuk. Her brother is Bob Barker and stuff, and she never really got. And so my mother's it's a good person, and her husband or a husband or second husband is the Brigadier General Anthony McAuliffe. I'm well known to the government.
Mr. Holt,
The judge asked whether Mr. Holt has questions about his rights, and instead of asking about the evaluation, the hearing veers into Germany, Roman law, ancestry, John Wayne, Bob Barker, and government recognition. That response is exactly why competency is on the table. The question was narrow. The answer was not. A court does not need a defendant to be a legal scholar, but the defendant does need to track what is happening well enough to participate meaningfully. This moment gives the judge even more reason to proceed with the evaluation because the courtroom is trying to discuss rights while Mr. Holt is building a conspiracy family tree.
Holt,
I will say, sir.
I'm taking the floor back from you,
Yes.
so you have to stop talking now. I'm ordering the Department of Human Services to conduct a competency evaluation of you. As soon as we get that report from the psychologist back, we'll bring you back to court. I'm going to review this matter in 90 days. That date will be? Good luck, sir.
God bless you.
The ruling here is clear. The Department of Human Services is ordered to conduct a competency evaluation, and the case will be reviewed in 90 days. That means the criminal process is not over. It is paused pending expert input. This is important because some viewers may think incompetency means the defendant gets away with it. Not necessarily. If he is found incompetent, the court can order restoration services. If he is restored, the case resumes. So this is not an escape hatch. It is a constitutional checkpoint. The court is making sure the defendant is legally able to face the charges before moving forward.
All right. I see that Mr. Holt is present in custody. How would you like to proceed?
I'm covering on behalf of Ms. Daly. In my notes, I have that Mr. Holt was just found incompetent to proceed but restorable. We would ask for an in-custody restoration. We'd also be
Now we get the answer. Mr. Holt has been found incompetent to proceed but restorable. That phrase is critical. It means the evaluator or court process has determined he cannot currently proceed with the case, but there is a belief that treatment or education may restore him to competency. This is not a final verdict. It is a legal pause button with a treatment plan attached. The defense asked for in-custody restoration and a Bridges liaison, which suggests the goal is to help manage his needs while restoration is happening. The courtroom is now focused less on guilt and more on whether he can be brought back to legal capacity.
We'd also be requesting a Bridges liaison. And I'll stop there.
She's saying stuff like, with levity, sir, not parody. Parody means I'm on par with you, and that would get me tossed from speaking. Levity means a little level. She's trying to talk over me. I don't know what the heck she's talking about.
Oh, stop and just listen.
Yes.
Mr. Holt, I'm going to give you the floor in just a moment. Right now, I'm listening to your attorney, so hold that thought and stand by.
Even after being found incompetent, Mr. Holt is still trying to litigate vocabulary in real time. Levity, parody, on par with you. He is drilling into word meanings while his lawyer is trying to address his actual legal status. This is a perfect example of why courtroom communication matters. The attorney is making requests that could shape where the case goes and how restoration is handled, while the defendant is reacting as if every phrase is a personal threat or hidden code. For a judge, that creates a difficult balance. Respect the person, preserve the record, and prevent the hearing from collapsing into a language debate.
Bye.
Please forgive me, Your Honor.
You were saying?
And then we'd also be requesting that this case is sent to the competency docket as well.
All right. I'm going to grant that request and order DHS to undergo restoration treatment for Mr. Holt. We will review this matter, or I guess DST will review this matter. Ms. O'Rear?
Yes, Your Honor. The people would be asking that this case stay in Division 21. It is a VRA case, and so just by office policy, we've been trying to keep those in the division to lessen the load of the work that the competency docket prosecutor needs to do, since there's often motions issues, bond protection orders, things like that. So the people's request would be to keep it in Division 21.
Ms. Kovach, what do you think of that?
Judge, my notes simply reflect we'd be asking for competency docket. I just think they're better suited to handle this case with Mr. Holt. And so that's our position.
I'm going to grant the prosecution's request and keep it in Division 21. So we're going to review this matter in 90 days. That date will be?
A little bit longer because that's vacation, so June 2nd.
Here, the prosecution and defense disagree on where the case should be handled. The defense wants the competency docket, likely because that docket specializes in competency-related cases. The prosecution wants it to stay in Division 21, pointing out that it is a VRA case and may involve motions, bond issues, and protection orders. The judge sides with the prosecution. That does not decide guilt. It decides case management. Courts often have to balance efficiency, victim rights procedures, specialized dockets, and the workload of different divisions. It is not flashy, but these administrative rulings shape how quickly and smoothly a case moves.
June 2nd.
June 2nd at 8:30 for review. Now, Mr. Holt, what is it you wanted to say to me?
May I stand up while I?
You may.
Okay. For instance, Shire is a township of in the English language. It's a beautiful thing. The Shire is like a township, and he was also a sheriff in Old England, whereas the King of England couldn't do that stuff, so he had the local sheriff do everything. The Crown Prince is the district attorney, and well, women could do it too. They say there's no women preachers, but there is. So technically, it's all. For instance, there's no 3x5 cards. It was all just word of mouth, and maybe 3x5 cards. Very few people, if ever, do this type of thing. And so the yellow fringes on the flag mean it's under admiralty law of England, because we come, all the bastion of law comes from England. The English people are very beautiful people, in fact.
And once again, Mr. Holt is given the floor and immediately returns to English law, sheriffs, crown princes, admiralty law, and yellow fringe on the flag. This is classic sovereign citizen adjacent material. The belief that hidden legal meanings, courtroom symbols, or old historical concepts somehow override modern criminal procedure. But courts have heard these arguments for years, and they do not work. The yellow fringe theory does not erase jurisdiction. Calling the district attorney a crown prince does not change the charges. And invoking
Mr.
Old
Holt,
England
I'm
does not
sorry to
convert
cut
a
you off, but
Colorado
let me just
courtroom
say
into a
one thing.
maritime tribunal.
Would I be released?
judge lets him
what
speak
was she
briefly,
saying
then
in
redirects.
effect in her legal speak that am I released pending care with the, I say Hope Springs Grove is a very good place, but what is the extant plan going on?
I'm appointing a Bridges liaison who is someone who can assist with your needs while you're undergoing restoration treatment. When you talk about the English law and American law, they're going to be discussing those
Common
topics.
law is better than anything.
I agree. And they're going to be discussing those ideas with you in the classes they're going to send you to. I'm going to review your case in 90 days to see if you've been restored to competency. And we can finish this
The
conversation.
judge's response is surprisingly strategic. Instead of debating every inaccurate claim, he says the Bridges liaison and restoration classes can discuss those ideas with him. Translation: this is not the time, place, or legal posture for a lecture on English law. The court is telling him, in the calmest way possible, that the system has already identified the problem and created a path for restoration. That is important because arguing with delusional or pseudo-legal beliefs can waste the entire hearing. The judge keeps the proceeding moving while still acknowledging that Mr. Holt believes these topics matter.
Finish this conversation at that time.
But would I be released in care of Hope COS or?
Not now.
What happened is I got a lawsuit that's gonna net me multi-billions of dollars.
Sure, and you're going to need to let that lawsuit take its natural progression.